Greetings, my name is Sebastian Watt and I'm here with my colleague Kyle Soley, and this is the fourth video in a series of videos talking about federal tax reform. In the first three videos we talked about the deemed repatriation, GILTI, bonus depreciation, and the interest expense limitations. In today's video we're going to talk about how rolling conformity states might not actually be rolling conformity states. With that, I'll turn it over to Kyle to take it from there.
Yeah, so there's a lot of things in tax reform that taxpayers don't like at the state level. I mean, I don't think anybody doesn't like the lower tax rate at the federal level, but there are things that folks don't like at the state level. The deemed repatriation, the GILTI that they have to deal with. They'd like bonus depreciation, but most states decouple from that, and you have the interest expense limitations and so on. Lots of things that are not positive at the state level. And I think that the conventional wisdom when you listen to all these teleseminars is that it is crystal clear that if you're a rolling conformity state, in other words, you just pick up the latest version of the Internal Revenue Code, that we automatically pick up all of the tax reform changes. We want to argue here today is that there is a position, there's an argument in a lot of the rolling conformity states, not all of them, but in a lot of them, that that's just not the case. So what we want to do is talk about what the basis of that is. Well, the basis of that is the non-delegation doctrine. The non-delegation doctrine is a doctrine that is in place in pretty much all states that says that the legislature, that all laws have to be enacted by the legislature. And what that means is that the legislature can't delegate to someone else its lawmaking authority. So for example, a lot of the cases on this go back to Prohibition. It's interesting when you look at this, go back to Prohibition. And of course, we had Prohibition in this country early part of the last century, and there was the Volstead Act, which the Congress used to carry out Prohibition, which defined whether a beverage was or wasn't alcoholic. And the question in a lot of states was, could we just look to the Volstead Act to determine whether a beverage is or isn't alcoholic for state purposes? And the answer in most of the states that looked at it is no. You can't just refer to the federal government's definition of what is alcoholic or not on a prospective basis. In other words, you can't say, we're not going to make a determination now, and the federal government hasn't yet made a determination, but when they do, we simply adopt their determination. And that's an important aspect of this. When you look at the non-delegation doctrine, what it typically says is that a legislature can't defer to another body to make law, but it can refer to another body that has established a criteria in the past, or a criteria that's static. And that's important here, because it doesn't mean that the non-delegation doctrine prevents states from referring to federal taxable income. So how does this come into tax reform? Well, most states refer to the Internal Revenue Code to define taxable income for purposes of state taxes. Those that do so on a static basis are looking back, the legislature's looking back to a definition that already exists, and they're saying we are going to, as a matter of policy, we've evaluated that definition, and we're going to adopt that definition as our law. The non-delegation doctrine says you can't do is you can't look to essentially a thing that is not static, a definition that is not static. You can't, the legislature can't say, we're going to look to whatever this other body does in terms of defining this term, from here on out. So for tax purposes, what the non-delegation doctrine would say is you can't say, we're going to adopt federal taxable income that Congress has established today and that it may define in the future. Because doing so would be abdicating their role as a legislature as making a policy choice for the state. So you may say, well, we know some states do this and there hasn't been a problem with it. Well, some states have actually added to their state constitution a provision which specifically allows the legislature to conform on a rolling basis. In other words, although the legislature generally has the exclusive authority to adopt laws, those states in their constitutions say, except for tax law. So New York is an example. New York in its constitution explicitly says that the New York legislature essentially can delegate to Congress the authority to define taxable income for tax purposes. But a lot of states don't do this. For example, Pennsylvania is one, and Pennsylvania is one where there's good case law in Pennsylvania that tells you that you can't delegate to the federal government to do something in the future. And of course, on most heat maps, Pennsylvania is listed as a rolling conformity state. In fact, as recently as last year, the Pennsylvania Supreme Court reaffirmed this concept of non-delegation. The legislature had delegated certain medical safety standards to a third party, and didn't say a static standard in the past that's been established already. It said, and whatever standard that body may pass in the future. And the Pennsylvania Supreme Court says, you, the legislature, can't do that. You can't adopt things on a rolling conformity basis in that regard. And we think similarly that Pennsylvania courts would likely say that you can't adopt changes in federal taxable income on a rolling basis. So what other states is this an issue? Well, what you need to do first is you need to look at, okay, what are my rolling conformity states? And then you need to say, well, then there's a bunch of states that have, like New York, have already carved out or made an exception from the legislature's exclusive legislating power, allowing for tax purposes rolling conformity to federal taxable income. But there are 8 states that have not. And these are the 8 states: Alabama and Kansas, Maryland, New Jersey, Oklahoma and Pennsylvania, Rhode Island. We talked a little bit about Rhode Island in our last video. Rhode Island and Utah have rolling conformity, but do not have an explicit provision in their constitution which allows the legislature to simply roll along with whatever Congress does. So in these states, if the various provisions of tax reform are causing a particular headache, a particular problem, take a close look at this non-delegation issue. So that concludes our 4th and final video. We thank you for joining us. We hope that you found them useful and informative. Thank you.